It's 2 o'clock, and this is the time for our live webcast of a legislative preview. My name is Scott Carpenter. I'm an attorney here at Carpenter Hazlewood, and assisting me today is my law partner, James Hazlewood, who will be monitoring the chat window. Our goal today is to do a quick down and dirty of some of the bills that have been introduced at the legislature and to kind of give some indication of where things might be headed. A couple of things by way of background. There is a chat window there, and if you have a question, feel free to type it in there. James Hazlewood will address it or address it to me if necessary. And this broadcast is being provided on January 22nd, 2013. It will be available on our website in the library section of our videos. And just so that you're aware, if you're watching this not live, this is accurate as of January 22nd, 2013. And it is intended to simply be a window in time. This is not a summary. We are in the middle of the legislative session. It just started a couple of weeks ago, and these are the bills that have been introduced. So this is a legislative preview in 2013 only. Please don't watch this to know what the laws were that changed in 2013. The dance of legislation takes a long time, and there's no way to know from what's introduced what will actually become law. By way of resources today, there is a website called www.azhoalegislation.com. That's a blog, and I'd love for you to go there throughout the legislative session to monitor what's going on, what's been introduced, when the hearings are, opportunities for you to get involved, and that resource will be updated periodically. You can also subscribe to email inside that blog, where you'll get an email on days when there are changes to the blog and no email on days there isn't. This year we made the decision to clean out the old list, and so if you previously subscribed, you've got to resubscribe so that we're sure that the people who want the information can get it, and the people who are no longer interested in the information are not going to get it. So feel free to subscribe to those digests. It's free of charge, and the email list that's created by that blog stays with the blog. It doesn't get used for anything else. We're not selling the list or giving it to anybody, we promise. Another resource, the place I go for a lot of this information, is the legislature's own website, azleg.gov, and that's where you can find copies of the bills that have been introduced, the status of bills and things like that. And you can either go to my blog for the information that's limited only to the HOA bills, or you can go to the state legislature's website as well, and we invite you to use both resources as much as possible. All right, so far this legislative session, 10 bills have been introduced, and last year at this time, I looked back in my notes from my 2012 legislative preview, there were 15 bills. So by that indication, perhaps it'll be a little bit of a lighter legislative session, but then again, you never know. And by the quality of this year's introductions, as you'll see, some of them are a little wackier than others, and we'll have to see how the legislative session goes. There is no particular deadline, although the legislature does have a number of deadlines embedded in their own rules. There are always ways for bills to be introduced later or for new concepts to be introduced as amendments to existing bills. So this is by no means intended to be complete. New bills could be introduced tomorrow, the next day, or the day after that. And as I said earlier, today is a snapshot in time only. It's what's going on today and what can we kind of roughly anticipate this legislative session, which should last 100 days, but often lasts longer, and so we don't have any idea when the legislative session is going to be over. One note about advocacy. Advocacy is this idea that as a citizen of the state of Arizona, the legislature wants to hear from you and that they care what you think. And a lot of people look at these issues and say, well, I'm just one person, or the board of directors, we operate in this little environment over here in our corner of the world. Who cares what I think? Well, it turns out that advocacy matters. I've been a volunteer lobbyist at the legislature for probably about 15 years, mostly through Community Associations Institute as a member of the Legislative Action Committee and chair or co-chair over the years. And a couple of things I've picked up along the way is that not all advocacy is equal. There's a hierarchy of effectiveness of advocacy. I'm going to put them in order. This is sort of Scott's version of effective advocacy. The far most effective advocacy is face-to-face. Meeting with your legislator, a face-to-face meeting. Shake hands and say, I'd like to tell you about my perspective about what's going on with HOAs. Whether you think HOAs have run amok or you think HOAs generally should function without regulation or somewhere in between, face-to-face advocacy is the number one way to be effective in communicating your point of view. The second most effective is a phone call. Even if you don't talk to the legislator, the way these phone calls are recorded at the legislature makes your phone call, even if it's a message that says, please register me as opposed to Senate Bill whatever, that is effective advocacy. Third most effective is to actually write a letter. And when I say write a letter, I mean print it on actual paper, put it in the United States Mail Service with actual first-class postage. Very effective advocacy. And the least effective, and the fax would be a little less effective than a letter, but the least effective is email. Why? Because it's so easy. Anybody can do it. Email matters, and if that's all you have time to do, if that's all you have the resources and the energy to do, please, by all means, send an email to your legislators. But if you have the time, the energy to place a phone call or to write a letter or to actually have a face-to-face meeting, it is far more effective by factors of 10 or more than simply sending an email, so I encourage that. I'm going to now take the 10 bills to go through them in some detail. The first one, and in no particular order, is Senate Bill 1055. Senate Bill 1055, if enacted, would apply to planned communities and condominiums, and it's very simple. It would require condominiums and planned communities to permit the unannounced entry of private process servers into the community if the process server is duly appointed or registered. Now, to a lot of communities, you'd say, well, what's the big deal with that? We let them through anyway. And for gated communities that don't care about process servers, in other words, a guy rolls up in the car and says, I'm a process server and I'm here to serve Sue Johnson in Unit 27, for associations that have historically said no problem, this bill would not offend you. But there are some gated communities that say, hey, we take our access control gates very seriously, and if someone's not authorized by an owner to be there, we don't permit it. And so this bill would offend those associations that have historically done this. An additional perspective on this bill is that it's part of, one could say that it's part of a regulatory creep that says we know better than HOAs, we think that the gates shouldn't really be that restrictive, and even for non-gated communities that see this bill as a kind of creep on their brethren, there would be an opportunity to object to it on a philosophical basis. So the first bill is Senate Bill 1055. Last year, a similar bill was introduced. It was not passed, and it didn't make a whole lot of progress, so it'll be interesting to see where this one goes this year. Senate Bill 1055. One thing I forgot to mention, and I apologize, is that there's a handout that you can download in this video window. And the handout has 37 pages, and it's actual copies of the bills that have been introduced. And throughout this presentation, I may reference a page number here or there. But in the handout, the bills are in the order that I'm going to talk about them. All right, the second bill has to do with resale disclosure fees. And this bill would address the cap again. A cap was introduced a couple of years ago of $400 on the fees that an association can charge or its management company for resale disclosure, transfer, lien estoppel, and other services. And if this is enacted, then the association can increase the amount of money that's charged by no more than 3% for each year, beginning with what's charged on January 1st, 2013. I'm going to need some water. So this is an attempt to increase this and to cap it at 3% per year, obviously to account for inflation, and it'll be interesting to see where this bill goes as well. So that's the second one, House Bill 2092. Sorry, I didn't move the PowerPoint. To permit a 3% increase per year. All right, the third bill, and if you're following along in the handout, it's on page 12, is House Bill 2135. House Bill 2135 is a bill that would apply both to planned communities and to condos. And this is a bill that would basically do two different things. The first one is that it would require associations to provide for voting by use of electronic mail and by use of facsimile delivery. And this is interesting in the sense that it would require associations to provide for this kind of delivery. Now, for a lot of associations that are what we call on the grid, maybe perhaps in Phoenix or Tucson or have professional management that's capable of all of these things, it would be rather simple to provide for voting by email or facsimile delivery. There's a lawyer representing community associations throughout the state of varying sizes and various management types, including volunteer management where the board members do all the work, a legislative requirement that the association must provide for email voting or by facsimile could actually create a bit of a problem. A lot of associations no longer maintain fax machines, for example, and to require them to be able to accept a fax would actually be quite inconvenient for some. And the idea that an association must take a vote by electronic mail begs the question. In a volunteer-managed association in one of our rural counties where the board members do all of the work, that would require on some level perhaps that the owners be able to vote to the personal inbox of someone on the board. And there's not a lot of protection there. So it would be interesting to see how the legislature reacts to this when a lot of folks in the association side might say, how can you mandate that we accept them? Now, if the bill were to say that an association can, if it wants to, accept voting by electronic mail or facsimile, that would seem to be a provision that would be universally liked by associations because it would give associations flexibility rather than mandating the associations that are not prepared for electronic mail or facsimile to be mandated to develop electronic or facsimile infrastructure to do it. So that's the first half of House Bill 2135. The second half is a little more curious. It would essentially say, we're on page 14 of 37, the blue letters, and what it essentially says is that after the period of developer control expires, a declarant employee or the developer could not be on the board if there's more than one person on the board who is an employee or an affiliate of the developer. And although this may make sense initially, the challenge that it will create for some boards is that people who work for developers and builders have to own a home somewhere, have to live somewhere. And often employees of home builders or developers end up buying homes in the communities that they build. And if after the period of developer control, that homeowner can't run for the board because he or she works in the customer service department of a home builder, would restrict that association's ability to elect the directors they want. So it'll be interesting to see how the legislature reacts to this proposal, given the fact that it would, on some level, restrict the ability of the owners to elect the directors that they want. Okay, moving along to the next one, which is House Bill 2145. I've called this one Agency Authority, and that's what the bill is called on page 16 of the handout. On this bill, it would apply to planned communities and condominiums, and the gist of it is that it would permit a management company to act as an agent for an association to the extent that the agreement between the association and the management company allows it. And so we'll be looking forward to see how the legislature reacts to that proposal. The next bill is House Bill 2460 on page 18 of the handout. It's called Master Association Dues, and I would put this bill in the category of the most intriguing. In other words, it's the most interesting and kind of hard to understand of the bills that have been introduced. As I've read through it several times, the best I can glean is that it would apply to planned communities only, and it would allow owners to avoid certain master association dues, but in order to do so, you have to meet a number of requirements. And the only thing that I can sort of surmise from this bill is that it's been enacted to address a very specific situation. Reading between the lines, and I don't know anything about the bill or the circumstances, and hopefully I'll figure it out here soon in the volunteer lobbying that we do here at Carpenter Hazlewood. The best I can figure out is that there are some owners somewhere in the state who are feeling that they shouldn't have to pay certain kinds of dues or assessments to an entity that they call a master association in their vocabulary or vernacular, and that this bill, if enacted, would perhaps exempt them because that particular situation meets the exceptions or the requirements in the statute. The biggest problem with the bill that jumps out immediately is it does not define the term master association. Now, those of us who have been around the community association industry for a while, we know it when we see it. Master association is a large community where there are smaller associations underneath the umbrella of the big one. But when the term is used in law, and there's no definition, it leaves a lot to the imagination. And in good legislation defines terms, and that's the biggest flaw, is that until now, the word master association has never appeared in the statutes in this way, and to use it without definition is going to create a tremendous amount of confusion. So, like the other bills, I'm anxiously awaiting to see how the legislature responds to this particular proposal. All right, moving along, the next one is what I call registry, House Bill 2274. This bill is quite simple and straightforward. It would apply to planned communities and condominiums, and it would require registration of each condominium and planned community with the Secretary of State's office starting January 1 of 2015. And within a couple of months after that, the Secretary of State would be required to make available on the internet all of the information that the associations have recorded. The information is the information that's currently required to be registered or listed with the county recorder in the county where the association exists, plus a couple of other pieces of information that are not that different or onerous. And it would also permit nonprofit corporations in Arizona to bid for or compete for the right to operate the registry as a kind of contractor of the Secretary of State's office for a term of 3 years with an option to renew for a term of 5 years. And the bill provides that this outsourced nonprofit entity that's providing the registry services could charge a fee for the registration. This bill is similar to, if not identical to, a bill that traveled through the legislative process last year and was actually vetoed by Governor Brewer after the legislative session was over. So it'll be interesting to keep an eye on this bill this year as well. All right, the next one. We call this one administrative hearings. Over the years that the alternate dispute process available at the Department of Building, Fire, and Life Safety has been enacted, we have struggled a bit to give it a name that can be universally recognized. So we've variously called it the ALJ process, the administrative hearings process, or even the DFBLS process, the Department of Building, Fire, and Life Safety. This bill would apply to planned communities and condominiums as well, and it does two things. It first says that if a petitioner by an owner wants to dismiss it, and before a hearing is held, they get their filing fee back. So the idea here is that the owner can, anytime before the hearing is held, say dismiss it and get their filing fee back. And that may be somewhat innocuous, but I guess there's somebody out there who wanted to dismiss it and didn't get their filing fee back and perhaps thought it'd be better to go to the legislature to get that fixed. So that's perhaps neither here nor there. But here's the part that's more interesting and perhaps more onerous and has a lot of potential consequences. There's a new provision that says that the petitioner, when they win, can have their attorney's fees paid by the loser, which in this context we typically call the respondent, so that the winner gets their attorney's fees paid by the loser. What's interesting about the way the bill is drafted is that this provision has what we call no reciprocity. In other words, if the respondent wins, they don't get their attorney's fees paid by the petitioner, but the petitioner would receive their attorney's fees paid for by the respondent if they win. Now, as a matter of statistics, having been involved in this process from its inception a number of years ago, the vast majority of disputes that are lodged with this alternate process are filed by owners against the association. Very few associations, and maybe a couple of times it's happened, have actually used the process as the petitioner. So when a provision is introduced that says the respondent is going to pay the petitioner's attorney's fees if the petitioner wins, as a matter of statistical reality, this is in there to say homeowners, when they hire an attorney and go to the alternate process and they win, should have their attorney's fees reimbursed by the association. But if the homeowner takes the association to the alternate process, the association wins, each side has to pay their own attorney's fees regardless of the outcome. For me, I find that fundamentally unfair, and if the bill is going to progress, hopefully it will be changed to say whoever wins petitioner, respondent, whatever, can apply to the administrative law judge to have the attorney's fees paid by the loser, regardless of whether it's the petitioner or the respondent. Okay, a couple more. The zoning bill, which House Bill 2474, page 30 of 37 in the handout, would apply both to planned communities and to condominiums. And this is curious. There was a bill introduced last year that had the essence of the same thing, but this year's bill is drafted quite differently. And the essence I speak of is this idea that municipalities, cities, should be prohibited from requiring a developer to set up an HOA as a condition of approval of their development project. The theory being that there are so many HOAs in the state because municipalities are requiring builders as a condition of their right to build a project that they create an HOA. Embedded in this position is the theory that if the city didn't require it, developers wouldn't build them and purchasers wouldn't demand them, which is a philosophical question that I suppose would be tested if this bill were enacted. But it essentially says that cities will be now prohibited, if this is enacted, from requiring an HOA as a condition of development of the property. There are some exceptions, and if you look at page 31 of 37 of the handout, you'll see them there. And it's a curious list. I'm going to give them to you briefly. A municipality can require a developer to set up an HOA if the association owns or is otherwise liable for the costs of any one or the more of the following special features, as the bill calls them. A golf course, one or more lakes, a swimming pool with an area of more than 1,200 square feet. I guess if the pool is 1,000 square feet, you wouldn't be able to require an HOA. So there's a 1,200 square foot minimum for a swimming pool to allow the municipality to require an HOA. A clubhouse or other community building that is more than 2,500 square feet. An orchard or other agricultural feature that in the aggregate covers 2 acres. An equestrian area or facility, a landing strip, runway, or other similar feature designed to be used for aircraft, commercial property, a public or private school, or one or more churches. But a playground equipment or something like that wouldn't qualify to allow the municipality to require an HOA. So very interesting to see where this goes. And a particular interest will be whether the League of Cities and Towns decides to weigh in on this particular proposal. As I said, a similar proposal was introduced last year. It didn't make much progress, and so it'll be interesting to see where this one goes. All right, the next one, tenant information, we call it. House Bill 2337, page 33 of 37 in the handout. This bill is one that would apply to planned communities and condominiums also. A very similar version, if not identical, was introduced last year. It passed both houses of the legislature, and the governor vetoed it. And similar to the registry bill, it would be interesting to see how the governor reacts to this one this year, if, like last year, it passes through both sides of the legislature. First thing it would do is allow third parties to act on behalf of owners, landlords, with the association. And although at first somewhat straightforward and say, well, okay, so the tenant can talk to the association about some complaint about weeds or something like that, or the association can talk to the designated third party about enforcement violations or whatever, it clashes a bit with the requirements that there are no proxies or that absentee voting, that the owner's going to vote. It's not clear whether this third party is someone who can vote at the association elections and at annual meetings. And at a minimum, it'd be nice to get some clarity on that. In addition, it caps the association's administrative fee to $25. It caps, sorry about that, I had a PowerPoint problem. It caps the association's administrative fee to $25 on the cost to gain information from the tenant, and There's a number of things that the statute would permit if it's enacted that would permit the association to gain some information, but most of it ties back to what the Declaration provides, and so there's not a lot here that empowers associations to do new things with tenants. It's mostly regulatory in the sense that it requires the association to deal with third parties, and it caps the administrative fee, and it caps it puts a maximum of the kind of information that can be obtained from landlords about tenants. And so last year, a similar bill was vetoed. Finally, there is a bill 2098. This is page 36 of 37. And if you're looking at it, you'll notice that it does nothing but add a word. We call that a technical correction. And this is often done because a legislator wants to have a placeholder bill so that things that come up later in the session can be attached to that bill, because there is a requirement of the legislature that future amendments to bills be germane or relevant or tied to the original topic of the bill. So we'll be keeping a close eye on House Bill 2098, although in its current form, it would have no impact on associations. Question from online?
A couple of points. Someone from CAI brought up the point that Kiowa has in it a provision about voting alternatives, but does not mandate it. It says unless you can do it unless the covenants say no.
There's a concept in the law in other states that says that you can. What was the question?
On
the email.
The email and other means of voting.
Yeah, Arizona has never adopted the Uniform Common Interest Ownership Act, and so there are some provisions across the country that would allow an association to provide for alternative methods of voting, even if the statute doesn't provide it. And in Arizona, we have talked about online voting and some email methods of voting, and even accepting votes by facsimile, but it's always been a bit of a gray area.
Iowa does not mandate it.
Right.
And the other thing, do you have any more specifics about that master association bill? A little bit about what it says?
Yeah, the question was, are there any more specifics about the master association bill? And unfortunately, no. At this moment, on January 22nd, I don't have any reconnaissance about what it's about or where it's coming from or what specific situation has caused it to come about. I'm sure the information will come out as conversations occur with legislators and lobbyists to try to figure out what's really going on. But at the moment, we don't have any other information.
Is this going to be every Tuesday?
Is this going to be every Tuesday? No, this is it. From this point forward, the place to go is to azhoalegislation.com. This will be my 4th year blogging the legislative session. This is not my first time. This is not some vision that I'm going to do this every day, but I might not get to it. I'm very consistent. This will be my 4th year doing it, and I promise that the information is going to be up to date and accurate. Every Friday, I will take the stuff that's happened that week and accumulate it into a Friday update. And so if you were inclined to check back periodically, I would check back every Friday afternoon, starting this Friday. And if you don't want to subscribe to email updates, you have to go to the website. But no, this is the only webcast that we'll do like this. If there's a lot of demand for it, perhaps we'll consider doing it each Tuesday or at some other predictable time. But at the end of the legislative session, we will be doing a legislative wrap-up where we talk about the things that happened and to give you some guidance about how you might need to come into compliance. Thanks for watching.